light on key legal barriers and explore policy reforms necessary to ensure gender equality and justice. We are honored to have a distinguished panel of experts with us today. I would now like to take a moment to introduce them to you. Ms. Visa Kegel, who will discuss personal laws, is an attorney at law with over 8 years of litigation experience, specializing in human rights, family law, public law, fundamental rights, land and labor law. Ms. Visa has represented victims of torture, arbitrary arrest, and domestic violence. She has also litigated public interest cases, advocating for stronger constitutional safeguards, accountable governance, and participatory democracy. We are privileged to have her join us today. Ms. Sarla Emanuel, who will address labor laws and debt, is a feminist, activist, researcher, and development practitioner from Eastern Sri Lanka. With over 2 decades of experience, Ms. Sarla has worked tirelessly advocating for the rights of Tamil-speaking women affected by war and violence. Her expertise spans women's right to development, gender-based violence, economic and labor rights, and the rights of marginalized communities, including LGBTQ+ individuals and women living with disabilities. We are honored to have her with us today. Dr. Chulani Kodikara, who will delve into laws relating to domestic violence in Sri Lanka, is a researcher and a member of the Social Scientists Association, where she also serves as part of the editorial collective Top Quality Magazine. With extensive experience in research and policy engagement, she has worked with institutions such as the Consultation Task Force on Reconciliation Mechanisms, the International Center for Ethnic Studies, the Muslim Women's Research and Action Forum, and the Ministry of Foreign Affairs in Sri Lanka. Ms. Pujani Galapati is an attorney at law specialized in corporate and company law, labor law, administrative law, and tax law. With a strong background in legal research, drafting, and general court procedures, she is also well versed in company secretarial work. In addition to her legal career, Pujani is a freelance journalist writing on culture and contemporary social issues. Her passion for both law and journalism allows her to navigate complex legal landscape while shedding light on pressing social matters. Moderating this important discussion is Professor Farzana Hanifa, whose extensive expertise in general studies will undoubtedly serve as a valuable guide throughout this session. And dear panelists, kindly note that each of you have a time limit of 10 minutes to present your ideas. So let us now proceed with the discussion.
Thank you very much, and I welcome all the panelists. Thank you so much for agreeing to speak at this event. I think the excellent presentation by our chief guest has really set the tone for us to take off into a very detailed discussion of all the issues that she raised. Thank you, madam. Fantastic. We are really happy about your contribution, and hopefully the discussion will illuminate many of the points that you have already made. So thank you. Okay, Ms. Teagle has told us that she has to leave early, I think. No? So I will invite Nizam to speak first, please. 10 minutes.
Thank you. Chairperson, Honorable Justice Degdenia, Commissioner of the Human Rights Commission, Ms. Farzana, Ms. Council, distinguished guests, friends. I really do think that the speech by Ms. Jamil really sets out the enormity, the breadth, and the pressing nature of the challenges facing women in Sri Lanka today. I, in my 10 minutes, just wanted to basically trace the discrimination that women face in personal laws in Sri Lanka. Very, very briefly, I think some of it has been set out already. Look a little bit at the history of how these laws came in, the context for reform and why it's so hard, and how to really take this conversation forward. In setting out the discriminations in under Canadian law, and this very briefly set out, We know that there are two types of marriages, legal and Vibhinna marriages, and we know that in the Vibhinna married widows, there is no right to the paravali and acquired property. We know in legal married daughters, they relinquish their rights to inherit the father's estate. You know, the widows are only entitled to acquire property of the wife, which was acquired during the pendency of the marriage. And there are these inconsistencies and disparities between the rights of widows and widowers in the different types of marriages. We know in intestate succession that illegitimate children are unfairly treated and do not get to inherit immovable properties. That is under the Canadian law. Under Kesavalami, as was said, we know that married women subject to the Kesavalami law also do not have the right to alienate their property without the permission of the husband. Under Muslim law, there is a slightly longer list. The issue of not having a minimum age of marriage leading to child marriages, not having the bride not having a place to sign on the marriage registration document, leading to a situation where there is no consent that is formally obtained, legally obtained for that marriage. The issue of polygamy, which is practiced without any conditions, any criteria, leading to unfairness, leading to immense cruelty and hurtfulness within the relationship as well, and also destitution of first wives, the children, and there's a real call in that, in response to that, for the abolishment of polygamy by certain quarters. The issue that dowry is still recognized in the Muslim Marriage and Divorce Act. Maintenance and alimony. Alimony is not recognized explicitly in the law, and that right ought to be there. Maintenance, I think, is an issue across the board for all women in Sri Lanka, the adequacy of maintenance, how you calculate it, what is due. I think particularly within the Muslim Marriage and Divorce Act, which is implemented by the Qazis, we see a severe disadvantage in terms of what kind of maintenance amounts, values are allocated or ordered. Equality in terms of the divorce procedure is also an issue in Muslim marriages. Men have a different procedure, women have a different procedure. Women's procedure relating to women results in very long, drawn-out divorce cases, which then get embroiled in appeals for years and years, not allowing the woman to move forward, to enter into a new marriage relationship, and look after her children. And that suffering is also something that has been consistently highlighted. Property rights, again, across the board, I think there is that unfairness in family law itself, but the Muslim Marriage and Divorce Act does not even deal with it. So there is many a situation, many cases that we know where women become destitute as a result of the divorce. They lose the properties they came into the marriage with as a result of the divorce, and are left poorer still, having to go back to their families, sometimes having entered into a marriage at a very early age, then not being able to have an occupation, livelihood that then sustains them and their children. So there is a host of issues of discrimination within the Muslim Marriage and Divorce Act, which is why you see this loud call and a long-standing call from women's groups for decades. This is the landscape. In terms of the history of these personal laws, we must understand these personal laws as a colonizing project. It is when these particular, the Canadian Marriage and Divorce Act, the Muslim Marriage and Divorce Act, the Jaffna Matrimonial Rights and Inheritance Law were shaped by a colonial project which restricted those customary religious laws to these spaces. And by that shaping also distorted the law that was relevant at that time and that had the capacity to evolve. And now it has become crystallized, fossilized in these corrupt formations sometimes that we have today. And our communities are sometimes desperately trying to protect these virgins without then that understanding that personal law can even be evolved at this stage. You can reclaim it. better Muslim law, a more evolved Pesawalme law that is applicable to the communities and the times that our communities live in. So that opportunity to amend and evolve has really been lost in this conversation. And in that respect, I come to the context in which it has become so stuck. We do have a long history, a political history of oppression and discrimination against minority communities. And while you have seen the Candian law make very many amendments, the Candian law, we don't see any significant amendments to Pesawalme and Muslim law. And it is a reflection of that fear and oppression that the communities have felt, that then does not allow the reform conversation to take place openly. The resistance to reform is very real. We have all faced it in some form or the other. If you talk to those working particularly within the communities, the hardships that are faced, the attacks online, the attacks in society against their families, the inability to move around in day-to-day life because of what is said about yourself and your families openly. The alienation of these individuals from religion, saying that they are not Muslim, that they are Western agents, that all of that is part of the attack on which they face on a daily basis. This resistance, this fear of reform comes from this minority complex as well. And I think if you look at this as colonially shaped laws that have got stuck, and then we understand also the political context in which there is resistance to reform, there is a real responsibility in taking this conversation forward to do so responsibly and in an informed way. So we need to then understand the colonial backwardness that has informed these personal laws, the political and social culture that has long alienated, long disempowered, long oppressed minority communities in Sri Lanka, and that has to be a part of the conversation when talking about reform. And there has to be a real recognition at the end of the day. If you're saying it's going to take another 200 years to bring about equality, that cannot be the case, and we cannot stand for it. We have to recognize the patriarchal structures that are both in the larger political setup, I think starting from Parliament, right? And also within our communities that do not allow women to share in the decision making and in the power. So representation really is holding us back, the lack of adequate representation of women in Parliament, in decision making spaces. I think the leadership, and I'm ending on this note, the leadership that we want to see from the state, from fourth branch institutions, from us civil society activists working in this space, is that the conversation should really center on equality. Equality for all individuals, equality for women, equality for also minorities. It's part of the conversation. It is a conversation that we need to advance in terms of also revolution, power sharing, decision making. It is how we will then own these laws, personal laws, and evolve these personal laws. And it is really a conversation about rights of women and not being afraid to say we will move, that we need to have it now. I mean, we always hear this response to the demands that are made on all of these personal laws, particularly I think Muslim marriage and divorce law, because the demand has been growing. This is not the time. There is too much happening in the country, the community is under attack. It is always the time. And I think for the state, I think for fourth branch institutions, I think for us civil rights society activists, legal professionals and other professionals involved, there is no other time. Now it's now, because the suffering is now. And as day by day, it becomes worse. And with issues like the economic crisis, we are seeing it growing. And the lack of property rights really having an impact on the future. So on that note, I really think there is a context in which the conversation should be had. We should take everyone along with us. And I'm hoping that that helps shape the conversation moving forward on reform. But I really do think the urgency cannot be stressed more at this time. and really need to pull together not just the Muslim women who are asking for Muslim women's rights on this personal law issue, but everyone coming together, Muslim and non-Muslim, and all from all other communities, to look at personal laws and feel comfortable and feel confident in addressing them today. Thank you.
Thank you, Riza, for laying out very clearly the complexities that we face in trying to reform personal laws in the country. Now, the format through which we were going to do this section of the program was that we would have people present and then we would have a discussion in all three languages. But you need to leave. You can speak. That's fantastic. Okay. So then we will go with the program as decided. Now I would like to invite Sarah Mendes, who will talk to us a bit about labor and debt. Thank you.
Good morning, everyone. I'm actually honored to be here in a room full of committed state officials working for the rights of citizens of this country. And of course, I'm happy to be here among many of my fellow activists, feminist activists, trans women activists who are fighting for rights. So, thank you for giving me this time. I'm representing the Feminist Collective for Economic Justice, and I was invited here to talk about women's labor, economic empowerment, autonomy, and microfinance. So, as was said in the morning, it's extremely meaningful for me to speak about women's labor rights on International Working Women's Day, as this is the history of how the IWD came into being more than 100 years ago, with working women demanding their labor rights. I thought I will talk about women's labor, autonomy and empowerment rooted in my context in Batticaloa. Batticaloa is one of the poorest districts in the country, with women working primarily in informal economies of rural agriculture and fisheries. The only alternatives to this have been extremely precarious migrant work. Batticaloa also has a huge garments factory which employs close to 4,000 women and several other factories, garments factories as well. Firstly, on microfinance and household debt, working women in Batticaloa, like in many other post-war districts in the north and east, have been caught in predatory microfinance systems, often leading to increased domestic violence and at times leading to suicides. In 2018, like in other districts, there were protests against microfinance companies in Batticaloa after 17 people took their own lives due to debt. By 2024, victims of microfinance debt traps across the country challenged the Microfinance and Credit Regulatory Authority bill. Victims' petitions stated that the bill did not propose caps on interest rates, excluded the big microfinance companies, and did not protect victims from harm, and instead criminalized those who are unable to pay back. This is a heartbreaking example of what should not happen in terms of laws and policies. The Supreme Court ruled that provisions of the Microfinance Act was unconstitutional. In December 2024, more than 100 women gathered in Batticaloa to share experiences of the economic crisis and the IMF-backed austerity measures. It was the first time since the economic and political crisis in Sri Lanka that women from diverse economies came together. Women from the fishing sector, farmers, home-based producers, plantations, livestock and milk producer collectives, and others across 6 districts came together. The conference was organized by the Surya Women's Development Center. Women working in these economies have also been battered by decades of war, discriminatory laws and policies that have led to land dispossession, colonial bonded labor practices, war injuries, loss of working family members, and predatory microfinance systems. The sharing was rich, and there were many ideas for collective work and campaigns for socio-economic rights. Some of the recommendations from this conference are echoed by women in many parts of the country, and I would like to share at this forum as well. First and foremost, policies and legislations that value women's labor, which could lead to empowerment and autonomy, need to enact structural changes in exploitative, capitalist and precarious economies that we currently have. What does this mean? This means legal protections for workers in the informal economy, legal rights and entitlements including decent and increased wages, leave, pensions, maternity leave, and protection for workplace injuries and exploitation. Even if there are token pension schemes for farmers and fishermen, they are not easily accessible and amounts are very little. These are also extremely gendered and certainly not universal. They do not cover landless agricultural laborers and women fishers. To give a concrete example, I want to share the story of Vasanti. She is a woman living with disabilities due to wartime injuries. She survives by working as a domestic worker in different households. She cannot afford the transport for her health clinics at the government hospital anymore. The other day on her way to work, she was knocked down by a car and injured her foot. She was hospitalized for 10 days. Now she is home and cannot walk. She cannot walk, she cannot work. Her household, along with an elderly mother and school-going son, survives on her daily wages. Her wage is not legally stipulated or protected. She has no protections for injuries such as this, and she has no leave. Also, now that the burden of caring for her falls on her school-going son and elderly mother, she has no other support from state or any other sources. So if we are talking today about the empowerment and autonomy of women, then we need legislation and policies that protect Vasanti's rights as a worker and a citizen, including ensuring social protection for her as well as supporting the additional burden of care on her family while she is unable to work. This requires a structural rethinking of the economy itself. Don't forget, Vasanti still pays indirect tax of 18% while being wealthy, which is going towards increasing state revenue, a condition of the IMF. Secondly, there needs to be a gender audit of the impact of the austerity measures on women, particularly capturing the realities of the margins of society. Furthermore, there should be continued monitoring of the impact of rising household debt burdens and predatory microfinance schemes in the context of this economic crisis. Thirdly, and most importantly, a core dimension of working women's rights is universal social protection. There seems to be some confusion about what is universal social protection. The current budget, for example, includes EPF-PTF gratuity within the allocations for social protection. This is on the one hand, these are rights accorded to workers only in the formal sector. This is in a context where existing formal sectors such as the plantations are being informalized at a rapid scale. On the other hand, the arbitrary and precarious targeted social security mechanisms remain unchanged. To simply include existing legal rights using universality to increase numbers is an eyewash. It hides the reality that poor households, primarily working in the informal economy, are left out of social protection schemes and are subject to violent processes of targeting that leave them immensely vulnerable and competing with their fellow poor for crumbs. In terms of policies and budget allocations, universal does not mean putting different schemes into one pot and saying there are schemes from birth to death. Universal means every citizen has the right to it. Why is universal social safety important for the working poor? For working people from most informal labor economies in Sri Lanka, their main asset is their bodies. Without functioning bodies, they cannot survive. There is alarming data showing unprecedented increase in death rates, infant mortality, stunting and wasting of children under 5, particularly in districts like Batticaloa. This is government data from 2023. This is a direct indicator of the impact of austerity measures imposed by the IMF and accepted by successive governments. Increased taxes, continued low wages, removal of subsidized electricity, energy and water, and limited targeted social protection is impacting women's bodies as well as the next generation. Here we are celebrating International Working Women's Day in this hall in Colombo, when we know from government data that women and children are being gradually deprived of nutritious food. Even the existing state schemes have been reduced, their budgets have been reduced, not increased. Universal social safety makes basic needs accessible to working poor. It builds social cohesion and does not pit poor citizens against one another. This is essential to stop the violent march of the economic crisis and IMF-backed government policies that will destroy Sri Lankan society for generations to come. In 2016, when the public consultations for a new constitution were taking place, poor women from my district came in front of the committee and gave their recommendations for social protection. That it should be an entitlement, a legal right enshrined in the constitution. In fact, the final report of the PRC recommended in Chapter 12, right to health, right to food, water, housing, social security, and right to education. In terms of education, they propose language. Every person has the right to education, which shall be directed to full development of the human personality and the sense of its dignity, and the strengthening of respect for democracy, human rights, and fundamental freedoms. On this International Working Women's Day, I would like to assert again that we need similar language in the Constitution that states that every person to have the right to food, water, housing, and social security. I want to end with the current government's development plans to establish industrial zones and free trade zones in the East. This is happening in the context of absolute lack of space to organize workers in the garment sector and the IMF directly threatening against trade union action. Without vibrant trade unions working freely with a large membership of working women, how can we imagine that workers' rights will be protected? Our history has shown us again and again the exploitation that takes place in the garment sector. A vibrant trade union movement with many trade unions and women worker leaders is essential for democracy and to ensure women's labor rights. Any conversation on women's labor rights, empowerment and autonomy without having this as a core foundation has been proved over and over again to perpetuate exploitative and precarious economies that most women work in. An actual system change and a pushback on the IMF and other international actors can only take place with the political will of those in power, backed by strong people's movements, trade unions, and women's leadership. That is what the International Working Women's Day actually stands for. Without this, the working poor of this country, especially the women, especially those battered by war and by exploitative economies for generations, will remain dehumanized and disenfranchised as workers and as citizens. And that is a shame on this country. I only wish on this Women's Day that Sri Lanka will stand firm on protecting its working poor, as they are the backbone, not just of our economy, but of our society as a whole.